individually. Questions were asked by all parties, including the court. The motion is for mistrial. Mr. Brown, do you or counsel wish to be heard further on that after having talked to each of the jurors?
Yes.
And Mr. Irwin's going to do that?
If that's okay. Sure.
Just for the record, again, Daire Irwin, standby counsel, working with Russell Brown, who is bringing and has brought this jury trial, and on his own behalf, acting pro se. I do appreciate the opportunity to respond here, as well as the court allowing me to respond here on his behalf with regard to the legalities that have been brought forth this morning and then this afternoon. There was much discussion again in chambers on the record, where we went through after this morning, having heard from one juror that was indicating that there has been premature deliberations. The court, in an effort, and I think a Herculean effort, and I applaud those efforts, to make sure that Mr. Brown was getting a fair trial decided, and it was pursuant to a case that we all looked at, albeit it's uncharted water for all of us. We are trying to make sure and assure that Mr. Brown has a fair trial. We did have the opportunity, though, each and every one, including Mr. McNamara from the District Attorney's Office, to review People v. Or Banana, and that is 2018-39. It's still our contention, and I appreciate the court's is slightly different. Again, it's uncharted water for all of us, but it's still our contention that even without an additional inquiry into the individual jurors, the court can make and come back with a mistrial based on the allegations brought forth by one juror. I understand the court believes in this situation, and especially based on the case law and interpretation of the statutory provisions applicable in this case, that before they could do that, they would have to do additional inquiry. So our motion to deny, we raise that again, just to preserve it for the record, and I believe it has been already. But we did then go in, do the additional inquiry. It started out with one juror, again, saying that there's indications of a predisposition, that there were indications, more than indications. They essentially testified that they heard jurors on numerous occasions discussing the case. What we would consider premature deliberation. After polling each juror, then not polling, I strike that. After conducting further inquiry with each juror, I think that was pretty much affirmed unanimously. They all indicated that there was some discussion. It was a flashback to grade school, however, because nobody wanted to say they were involved. It was always somebody else. They, of course, could absolutely categorically be fair. And I'm not saying they couldn't by any stretch of the imagination. I'm just insinuating they all pretty much agreed, yes, there was discussion. We then learned later, after inquiring with the last juror, who was originally the one that brought these allegations to our attention, then we found out that there had been additional premature deliberation since the original report. And I can't see, on behalf of the defense, any possible way at this point that he can expect a fair trial. I mean, we're forever under the canons trying to avoid, even the mere appearance of any kind of impropriety, applying those same kinds of dictates to what we're talking about right now. I don't know how Mr. Brown could ever feel as though he's getting a fair trial. If the court's convinced otherwise, we'll have to take it up on appeal, I guess, or maybe pursuant to a 330-30 after trial if need be. But I would say this about the juror that came forward. I'm sure it wasn't easy to do. They were pretty much, to a juror, what they said was confirmed. Now, I suppose an argument could be made that juror number 7, if I can refer to the individual that way, that juror number 7 was telling the truth in part and not truth in part. That doesn't make sense to me because it's hard to come forward in that situation. And again, the most important things that were being reported were all confirmed by all members of the jury, namely that there were various discussions going on. And in light of that, you know, and nobody really taking personal responsibility for it, everybody kind of was making it appear as though it was other people, not themselves, in light of the fact that there was additional premature deliberation since the first recording. I cannot wrap my head around any conceivable way he can come on a fair trial or feel as though he got a fair trial. And we would move them for mistrial at this time based on not only the original allegations in this case with regard to the jury, but also then the additional information that was gleaned as a result of the inquiry conducted through each and every one of the jurors the second time for one juror in particular, but first time with regard to the other six. And again, I do applaud the court, because I know the court's made Herculean efforts here to make every effort to attempt to make sure that not only Mr. Brown gets a fair trial, but feels like he gets a fair trial. I just know that I don't think there's a way for him to feel it, and I don't think there's a way for him to get it. Thank you, Your Honor.
Thank you. Mr. McNair?
Judge, I would say that, you know, I would request, you know, that you deny the motion for mistrial. I believe that ultimately on this issue of whether or not they have in some way have been prejudiced or if that cannot be fair and impartial, which is a test at this point. To a person, in our discussion, they all had said that they would listen. They would all had said that they would be fair and impartial. They all had said, you know, that you know, there was some brief things that was very, they all characterized it as brief, except for the foreperson, or except for not the foreperson, the other juror that we spoke with twice. Defense counsel wants to fill out the document. She says, I don't know if I put much stock in what she says. You know, I appreciate the fact that she came forward. But 6 people said have it a different way. So at this point, I think we've discussed with everyone. You've admonished them, and I think we should deny the motion. Thank you, Judge.
Thank you.
I just do a short response rebuttal to that.
Sure. And I'll make this Carl, I'll make it short.
Very short.
I think the resounding issue that came through is the jury getting upset on the length of time.
That also concerns us. It seems as though we're more concerned. But anyway, succinctly put,
Do you want to do the mic?
Like, yeah,
Okay.
hold on.
The assistant district attorney indicates what they all said during the inquiry, that they would be fair, but they also all said when they took the oath that there would be no premature deliberation. And they all indicated that they heard people discussing the case. If we believe everything they said, then we also have to believe that there was some premature deliberation. And it happened even after the original recording. So I understand nobody wants to point fingers and no one wants to take responsibility for it. But the bottom line is, Mr. Brown is never going to feel, as I said, like he can get a fair trial, nor do we believe, I don't know what I call it, evidence, but all indicators are that he can't get a fair trial. And again, I want to thank the court for making the efforts it has with regard to this complicated issue. Thank you.
Nothing, Mr. McNair. Well, this is a new one for all of us. I think we've discussed that before. What concerns me is the one juror that came forward has a lot of inconsistencies in what she's indicating to us from the first time to the second time. Particularly, I think the first time she indicated one juror was predisposed to find the defendant guilty. When questioned on the second time, she indicated that was her opinion. And then she said, but the same juror was talking, according to her, was talking about finding the defendant not guilty. So I'm not sure what to believe at this point with that particular juror. What is clear to me is that each juror clearly said to me that they could be fair and impartial. They have an open mind. They have several questions. Many of them said they still have several questions waiting to be answered in their mind. I know most of them indicated there was discussions about drones. But at this point, using that standard, and I may well be wrong, and this may take, either a post motion or an appeal. But I'm going to deny the motion for the mistrial and let this go forward, fully cognizant that if there is a guilty finding, that there's probably going to be an appeal on this. Again, if there's a not guilty finding, an acquittal, I'm sure nobody's going to be appealing that issue. So we'll see how it goes. I'm going to deny the motion. And everybody's got it. I'll note the exception for you, Mr. Irwin.
If I could, Your Honor, just one comment with regard to the credibility of the juror that came forward.
You got to use my mic.
Oh, I apologize.
With regard to the credibility of the juror that came forward, originally she was saying that an individual indicated more likely than not that they could have expedited the process by just going guilty or whatever. And then with regard to the not guilty that she referred to later, that I think was her impression based on what the person was saying during the subsequent premature deliberations. So it's really, she's being consistent. She's just saying that the person might change their mind. Maybe they would be safe, but in both cases, there's premature determination. And that's what we're trying to avoid.
I understand your point. It's made for the record that we've made a record of all the jurors' answers, and it may well take a decision by county court to decide, whether it should have been a mistrial or not. But on the other hand, if it goes forward and it's an acquittal, it just won't be an appeal.
Again, Your Honor, thank you very much.
Okay, in that case, anything further before we proceed? Defendant, Mr. Brown, are you ready to proceed? Well, I'll have them check when they go to see.
Right, no, we're ready. I didn't know if we had time just to kind of get our thoughts together before they finish their lunches. I guess I'm just trying to gauge what our
Are they
time
still
is.
eating?
Right.
They're done? They're done eating, so. You ready to proceed, Mr. Brown?
Yeah.
Yes, Mr. Brown?
Yes.
Okay. Mr. McNamara,